controlled substance marijuana, contrary to state law, MCL 333.74012D, triple I. That's a felony punishable up to 4 years in prison and or a $20,000 fine, unless sentenced to more than 1 year in prison. The court shall impose licensing sanctions pursuant to state law. Upon conviction of felony or attempted felony, the court shall order law enforcement to collect DNA identification and profiling sample. So those are the charges against you. Today you've got the absolute right to remain silent. Anything you say can and would be used against you in a court of law. You have the right to have an attorney present during any further questioning and any further court proceeding. If you desire an attorney and couldn't afford one, then I would give you one at state expense. Did you need a court-appointed attorney, sir?
Yes, I do.
Okay. I'm going to have you fill out some forms for that, but I'll grant that motion at this time for a court-appointed attorney. So the next thing we have to do in this matter is set a date for a preliminary examination. The purpose of a preliminary examination is to see if the people have enough evidence to proceed with charges. And we'll set that for a week from today. That'll be Wednesday, May 29th at 9 o'clock in the morning. Is that acceptable to you, ma'am?
Yes, Your Honor.
Okay. Now, the last thing I have to do in this matter is I have to set the bond. And I'll hear from the people, and then if the firm wants to say anything about bond, you may too.
Thank you, Your Honor. Your Honor, we're asking the court to set a somewhat substantial bond in this case based on the charges. We're asking the court to set a $50,000 cash or surety bond for him and to require a GPS tracking tether. And the reason for that, Your Honor, is that this case is part of a larger ongoing homicide investigation. We expect there may well be additional charges, and we don't want him to, A, either harm anyone, or B, leave the jurisdiction. He has substantial ties outside of this jurisdiction. He is from Louisiana. He has previously worked as an over-the-road trucker and has a substantial record of contacts with the police in several states. So we're asking that the court set that bond, and we're absolutely asking for a GPS tether to be required. And additionally, if I might, Your Honor, the people have filed a motion to suppress the investigator's report and the witness list in this case, and I would ask the court to do that, as I said, because this is part of an ongoing homicide investigation.
Do you have any information about the defendant's prior criminal history?
I have a rap sheet from Louisiana. I don't necessarily have the dispositions of all of those cases. It's my understanding that he is on probation on a relatively minor matter in Dearborn, Michigan. He has previously been in prison in Louisiana for drug offenses, and he has a large number of contacts, Your Honor, for things to do with battery, obstructing police officers, disturbing the peace, unauthorized entry of inhabited dwellings, burglary, things of that nature. So while I can't tell the court I have the dispositions of each and every case from other jurisdictions, there's at the very least convictions for drugs. He's been in prison, as I said, in Louisiana, and a very large number of arrests for things that have to do with harming others and or obstructing police officers.
Sir, I'll give you a chance to respond in just a minute, and no one will interrupt you once your turn, but we can't interrupt her when she speaks. Let me ask you, ma'am, I noticed you did not charge him as a habitual offender. Why is that if you got all the prior convictions?
That's a good point, Your Honor, and we will amend the information to do that, the complainant information, and we'll bring an amended one to the preliminary examination.
All right, so that would, if he was charged as a habitual offender with a 4-year felony, what would that make this potential?
I believe that's 1.5 times the maximum penalty, Your Honor.
So you believe it's just a 6-year penalty?
At the very least.
All right. Mr. Williams, you're free to address me on the issue of bond. You don't have to say anything if you don't want to. If you want to say something, I'll be happy to listen to it. Let me tell you that when I said bond, I consider numerous factors, but the 3 primary factors I consider are the seriousness of the offense, the likelihood you may or may not come back to court, and the likelihood you might commit further crime charge while you're out on bond. Is there anything you'd like to say, sir, although you don't have to say anything if you don't like?
Really? I wonder why I haven't took a shower in 4 days. They tampering with my food. And I asked them about taking a shower. They said this facility is not up for shower. Then why is you holding me?
Okay, so you're.
And number one, I only been convicted of 1 felony. And that was for distribution of crack cocaine. That was 25 years ago.
Okay, well, as I said, the court's got to consider the seriousness of the offense.
And I ain't worried about bond now because I already know I ain't gonna bond now.
The seriousness of the offense that we have to consider at this time is not a homicide case. It's simply I say simply, but it is a deliver and manufacture of marijuana, delivery of manufactured marijuana. 2 counts of that.
2 counts. What's the second count?
Well, I got both of those counts to you, sir.
I ain't never delivered no marijuana to nobody.
All right. Well, you may or may not be innocent of these. That's not for decision today. Today, I just have to tell you what you're charged with, tell you what the maximum
And
penalty
why
is.
haven't I talked to a lawyer? Nobody wanted me to talk to a lawyer.
So, you don't get a chance to talk to a lawyer until.
Then why did they read me my rights?
Let me tell you something, okay? I'm going to go over it again, because I want to make sure you understand. You do not have to answer any questions or make any statements in court until you are provided assistance of the.
Then why is it that the detectives that are harassing me instead of coming to my cell and threatening me?
Here's what I'm doing, Mr. Williams. I'm providing an attorney for you. He will be here for you at the next hearing, May 22nd. No, I'm sorry, May 29th, 2013, 9 o'clock in the morning. So you'll have an attorney here. You don't have to answer any questions by the police. You don't have to do anything else until you talk to
Well,
them.
tell them to quit bothering me then.
All right. If someone questions you, you don't want to talk to them, just tell them I don't want to.
I told them, but they started coming.
All right. Well, we'll deal with that on the 29th. And on the 29th, people have to show that they have some evidence of all the elements of the crime you're charged with, or we'll dismiss the charges. But we'll deal with that on the 29th, not today. Okay, today's not an evidentiary hearing. So when you have your attorney here next week, next Wednesday, we're going to go through all of it. We'll make sure that people have enough evidence on all the elements you're charged with. Do you understand that or no?
Yeah, when is I'm gonna be able to take a bath, man? I've been there 5 days. Haven't took a bath.
I don't control the jail. They have their own procedures. I don't oversee that.
They gonna see it.
Well, we'll make sure that you get a shower or that. All right, so now the next thing we have to consider is the likelihood the defendant may or may not come back to court. According to people, and I'll take their word on it, he's a truck driver with a lot of contacts outside of the community. I have not heard anything that he has any strong ties to this community, so I see flight risk in this matter as high. As far as the likelihood he may or may not commit other crimes while he's out on bond, I've been given a list of charges that have been brought against him in the past. I do know that he was the subject of a search warrant that I had to sign to search his house related to a homicide, and so I am taking that in consideration. I'm going to set the bottom of this man another $250,000 cash or surety, and we'll see you back here on May 29th, 2013, 9 o'clock in the morning.
I ain't planning on burning out. But never planning on burning
All right,
out.
good luck to you, sir.
Good luck to you too.
Now, we have one other matter.
We do, Your Honor.
We'll take a short recess till the officers bring up the next
I
one.
apologize, Your Honor. Could I just inquire, is the court granting our motion to suppress the investigator's report?
Yes, I'll grant that.
Thank you.
Thank you.
Please rise.